Chair recognizes Senator the Honourable Fred Mitchell.
To win by one. No, don't, please. No, that's okay. I don't need it. No, yeah. There is, to speak first to the bill with regard to the question of an independent director of public prosecutions. There is a philosophical issue, and it is this: the assertion that there can in fact be an independent director of public prosecutions. My view is no such creature exists and can't happen. So if that's the premise from which we're starting, then we're starting from a false premise. And the other philosophical issue is whether or not the decisions with regard to prosecutions and the like ought to reside in a public servant as opposed to someone who's politically accountable to Parliament. And I believe in the latter. There is nothing that I see that has happened in this country that would cause us to have to pass this act to do what the government proposes needs to be done. In fact, what this bill does is largely codifies the practice which happens right now. Because although the public has this view that the Attorney General suddenly jumps up one day and says, oh, I'm setting so-and-so free, it doesn't happen that way. In fact, the Attorney General, more often than not, acts on advice. And we heard today the mover of the motion say that he wishes to remove himself from that final bit so that he does not bear the legal responsibility for having made the decision to prosecute or to stop a prosecution or to take over a prosecution. I believe that ought to repose in the exact person it's in now, the Attorney General, the political creature in the Constitution as it exists today. And as I was explaining to one of your members, you can disagree with the discretion as it's exercised, but it is a complete discretion. And the Attorney General exercises it any way he or she wishes to do. You don't like it, or you like it. That's just the way it is. But the Attorney General is accountable to Parliament, to the court of public opinion. And that, to me, is sufficient. And because the mover said that not only does not prevent a prosecution from being brought back, in other words, it's an act which is committed without prejudice, theoretically, his successor, if that successor finds that there is compelling evidence or reason to do so, can bring the matter back. There's nothing which prevents that either. So, this bill, then, as I said, codifies what is, in my view, existing practice, except for the removal of that last level. And I say this because there's an expression that the former Foreign Minister of Barbados used to use, which is you cannot approbate and reprobate at the same time. Another way of saying you can't give with one hand, or you shouldn't give with one hand and take with the next. And that's the way this bill is structured. Now, the government says that it is giving all of the powers, when you look at the bill, all of the powers which presently reside in Article 78 to the political Attorney General are now being transferred wholesale and without amendment to the new Director of Public Prosecutions. And so that is supposed to be that. If we are to have this, and I think they mean independent, not in terms of bias, I think they mean administratively independent. So the Director of Public Prosecutions is able to make the decision on his own, and that's that. But at the same time, the section of the bill gives the Attorney General the right to give general or specific directions in writing, and now we know they have to be gazetted, and these are supposed to be confined to public policy, to, yes, public policy, national security, and international obligations. The interesting thing about public policy, of course, is public policy can mean anything in the world. So that isn't confining either. I mean, I think that you would, the Privy Council's already pronounced on this policy, public policy issue when in Ryan and the Attorney General in 1980, they said that the Nationality Act ran afoul of the law because public policy was so general you couldn't actually say what it was. So I assume they've now decided on this gazetting mechanism to get around that. But the point is, you shouldn't approbate and reprobate at the same time. So the next point is the question of tenure. And the point we make there is that if you are giving someone tenure, you just give them a term. The term is 10 years. I think the American government, for example, after J. Edgar Hoover, who you use today, was there for his lifetime appointment, they provided an amendment to the act so the now director of the FBI gets to serve for 10 years. And that's it, 10 years. So there's no, at the end of 5 years, you be a good boy, and then I reappoint you for 5 years. That's the issue with 2 5-year terms. If you're going to give someone a term, give that person a term, and the term comes to an end. He doesn't have to look for any favor. He doesn't have to sweeten any pot in order to get reappointed. In fact, the way the Constitution now has this rider where judges are, they retire at 65, but they have to write before their 65th birthday, and then they get to hold on for another 2 years. So that is a very odd provision. And so what I'm saying is you're setting yourself up structurally for a problem here with two 5-year terms. Now, what I'd also like to ask, and perhaps on the wind-up you can clarify, is what happens in the existing laws? I think most of the sexual offenses, the Public Disclosure Act says something has to be done with the fiat of the Attorney General. So what happens in those cases? Well, you can do it at the wind-up if you want to do so. Yeah, right. Yeah, sure. Right.
Yeah.
Chair recognizes Senator the Honourable Carl Bethel.
I thank the Honourable Leader opposite for yielding. I'd meant to raise it in my initial contribution, and I thought that since it's topical now, it's best to address it now. There are a whole slew of enactments that have terms requiring either the fiat of the Attorney General, meaning the old Latin word meaning do it, to commence certain prosecutions, or the consent of the Attorney General for something. So, for example, if there should be an unexplained death in a family island, and either it's thought that the existing administrator is not competent or whatever, or there is no administrator functionally on that island, then the consent of the Attorney General is granted to remove the inquest into that unexplained death to New Providence. So a lot of these things are being looked at. There was a bill drawn up in 2001, but a lot of other laws have been passed since then with the same consent. What will happen is between now and the promulgation of the constitutional amendment, should it pass, is that we've already commenced going through them, considering each one, and we will come with a bill early next year to effectively transfer most, if not all, of these matters, most of which are technical, to the DPP.
Right. I thank you for that explanation, because I figured there would have to be many, many consequential amendments to deal with this if you say, as the Attorney General still appears in the law. So I've said how we philosophically deal with this, what we think of it, and why, at the end of the day, the vote will be to support it, because we believe it does not change the existing practice. It, in fact, codifies what you do now. And the fact that you even add this bit about Gazette, well, I mean, as I was saying to my colleague here, if you depend on the Gazette to frighten you, the Gazette takes weeks and weeks after the act is passed before you even see it. And I don't know who reads the Gazette in these days. But I take the point that you're trying to put this in the public domain and make an explanation. My concern there would be, are you setting yourself up? And I know thus far the case law suggests that the discretion of the Attorney General is not reviewable, is not justiciable. But the moment you start giving reasons for things, the moment you start doing that, you're laying yourself open to judicial review. And I say, again, to come back to the fundamental premises, this is supposed to be an absolute discretion in the Attorney General. That's why you have the political authority deal with it. And it's not the only instance where this occurs in the Constitution. Because if you find this offensive, you must also find offensive, I would suggest, the powers which are given to the minister responsible for the prerogative of the Committee on the Prerogative of Mercy and the exercise of the prerogative. Because if you look at that provision in the Constitution, it gives the minister responsible for the prerogative the absolute say over whether someone should be pardoned, whether the record should be purged, whether they should be let out on jail. And even though there's a committee for the prerogative, when you read the rules, it says that the minister, in fact, makes the decision. Life and death decisions. It's a political authority that does it. And there's again, I say there's sound and sensible reasons, sound and sensible reasons for putting this in a political authority. Because the political authority is ultimately responsible to the people, and the people ultimately have their say over whether that authority should continue to exist or not. And I'm very leery of an attack, and I know it's politically convenient, since we've just come out of this election and everybody wants to revisit history and dredge up what so-and-so did and this and that, but we know you can dig up many, many bones. I mean, the first time we heard about murder being a bailable offense was for someone who shot someone in the back, skipped bail, and then when the administration changed in 1992, got a nollie done by the then Attorney General. You could quarrel and argue about that. And of course, we took that to the political platform. And that's where it belongs, the political platform. Not taking away the discretion from the individual who is responsible for making the decision. There are sound reasons for that being done. And then, we can duke it out across the table here as we are doing now. No, and I want to come back to that case if you want to revisit that case. No, there was an argument. The member was just quoting from things that happened in Parliament. They raised it. They criticized the decision. There was a debate. There was a debate. Allegations were made. The answer was made that the acting minister said he made the decision in the resting on the rubric of national security, which is precisely one of the legs that the present practice says, the new practice that you're putting in place is saying that you can rely on, national security. So again, another example of why it's not new and why it's not different and why you're in fact codifying the practice. No, the only difference is that you disagree with the decision. That's the issue. You disagree with the decision. And I say that there was sound and compelling reasons, and I think the F&M knows better. Knows better. Sometimes, Madam President, there are some things which neither of us should say or argue in the public domain. And we said from the start, when this matter was raised in the other place, by the side opposite, this was not an appropriate thing to bring into the public domain. Not an appropriate thing to do. Because there were compelling reasons, all kinds of reasons which we cannot state, why an Attorney General may have exercised a discretion. But even if you disagree with that, what I want the other side, or I wish the other side could concede, is that there are some things which simply do not belong in the public domain. Do not. That's why, for example, the public records have been sealed for 30 years. You wait until the bodies are dead and gone, so to speak, before you raise certain matters in public. That's the existing law. In the archives, things go. That is why cabinet decisions are what they are. You are sitting in cabinet. You're discussing things freely with your colleagues. Those are sealed from the public for a period of time, for compelling reasons. Because when you're in the cabinet, you're supposed to be able to have a free exchange of information amongst your colleagues without other people looking over your shoulder to second guess what your most intimate thoughts are on policy. That's the argument. And similarly, it happens when the Attorney General exercises his or her discretion. So, in terms of the amendment which you offer, I would only say, be careful that you're not creating a situation where you are inviting the Looney Tunes from Grand Bahama to go to court and, you know, and review. Yes, right. No, I'm going to put it more specifically, right?
I think you should be careful.
Period. Yes, right. Okay. I won't. No, we know. You know, the lawyer who likes the vexatious litigant. Let me put it that way.
Vexatious litigating counsel.
Yes, I'm guided happily by vexatious litigating counsel, says the Attorney General, and I would draw and I would draw a Looney Tune. But the serious point is that you don't want to create jurisdiction which an authority or lay the foundation for making something which is justiciable, because it then creates a whole set of other problems. So that is our view on that. Secondly, Madam President, my colleague, Senator JoBeth Davis, spoke about the way we, the public who are outside the walls and the halls of government, saw a narrative unfold post the 10th of May general election. And it goes something like this. There was all this din about fighting corruption, you know, corruption. And we got the impression that a case was being built up for Victor's justice, which subsequently unfolded. There was a statement made by the former Commissioner of Police, Ellison Greenslade, to one of the newspapers, and he said words to the effect, well, I don't see, you know, a lot of talk about corruption, but nobody has formally complained. Then there was silence. And the next thing we saw was an acting commissioner was in place. And then 1, 2, 3 members of the PLP's former administration ended up before the courts on allegedly corruption charges. No sign of the Commissioner of Police substantively. A couple of weeks later, we then saw a note which was published that said, well, first of all, our members started asking questions. Where's the Commissioner of Police? Where's the Commissioner of Police? Where's the Commissioner of Police? A couple of weeks later, a note emerged. Commissioner of Police said, hi, fellas, my words, not his, I'm on holiday. I'm going to be on holiday for 3 weeks. Have fun. Obey the acting commissioner. He gave a date certain. The date certain came, We asked questions again, where's the commissioner, where's the commissioner, where's the commissioner? I think the former prime minister intervened in the public domain and said, you shouldn't be treating the commissioner this way. We didn't know what that meant, but we saw the words. And then there was another note. Hi, fellas. I know I said I was coming back on vacation today, but I'm going back on vacation again, and he gave a date certain. The next thing I heard, he had reported to the Ministry of Foreign Affairs. And the people were saying that he was going to be High Commissioner to London. So we put two and two together, and I guess that meant that the commissioner was leaving his office and taking a new post. Then we heard that there was a sticking point. The problem was that having served for the length of time that he served, he was unable to access the full pension as it was described by Senator Bethel in his intervention earlier today. And now we know the baton has been passed, and literally a baton was passed on the grounds of the barracks, one commissioner to the new commissioner. And I'm advised that the former commissioner is now safely ensconced in 11 Chesterfield House in Mayfair, which is the official residence of the High Commissioner. And given what we know about the way he's performed in his previous job as Commissioner of Police, he is likely to do a credible job in his new position. The issue then is not Ellison Greenslade per se, or himself. That's not the issue, him as a personality. And the issue is not for an individual to want to change his circumstances and take on a new job. The issue for us is, in the middle of what appeared to us to be a crisis on crime, the chief crime fighter of the country seems to have slipped away from the country and his job without explanation to the public and gone off to a new job. That's the issue. And that's not transparent. That's not transparent. My view is that one has to be careful how you offer or seem to offer public inducements to public officers to take various positions. And this has been a pattern because Bernard Bonamy, he had been Commissioner of Police for a long time. Suddenly, he decided he wanted to go back to law school. Again, this was all done, no transparent, this or other thing, fine. He left, went back to law school, resigned as commissioner, passed the baton, and then I think he ultimately ended up being secretary to the gaming board. Another commissioner of police followed the same path that this present commissioner of police followed, Mr. Paul Farquharson, who resigned, became High Commissioner to London. Now, again, I'm not turning on the personalities. I'm saying that if you want a transparent way of dealing with this, the person should resign the office and then take up the other office. And there should be no inducement, no persuasion necessary for that individual to do so. None. None. No, I'm saying that the job, no, inducement. No, the word I'm using is inducement. And I'm not going to answer, I'm not on your program. I'm saying inducement. Inducement. You see? No, I have to. Because, you see, the reason I use the word is because your mantra since you've been in office has been corruption, corruption, corruption. That's what I'm saying. So you have to be careful what you're doing if you say you're against it. And, he's a fine man. I mean, he's good, upstanding, good commissioner, has worked hard. No, I understand that. No. Sorry. We have a system that we're trying to protect. And we're in an argument about, and in a debate about the transparency of what, no, sorry. You know, everything is not as it seems. No, everything is not as it seems. Or it's often not as it seems. Let me put it that way. And then I have some, moving on from then, I want to also ask these secondary questions, if you may. The government. No, well, it's in the debate. It's in the debate, and there are issues which come with this debate and this piece of legislation. The government recently sent around a circular. The circular said to all permanent secretaries, and the circular said, I think it offered guidelines as to what is to happen when pensioners are rehired in the government service. Right. And I think what they've done, or what you've done now, is reverted to the position pre-2012, which is that if someone is rehired who is a pensioner, that pension ceases so long as that person is working in the government service. The advice which we had gotten when we were in office is that was unlawful, that someone's pension is their entitlement and that you cannot take away their pension entitlement, and you should not. That if you want to hire them, then you hire them. But you should not use that, taking away their pension away from them. And then the question is, you have two retirees who are sitting in the cabinet. If I'm advised properly, stand to be corrected. One is a former assistant commissioner of police, and the other is a police officer. I forget which rank he was that he retired on. So the question is, do these same rules, if I am correct, do these same rules apply to these two individuals that you are now saying must apply to these people who are coming back and rehired by the government? And then there are some sergeants, I understand, who are retirees of the police force, who have an issue about the collection of their gratuities, and have advised me that they're about to take an action in the courts because after many entreaties to the government, they are unable to collect a gratuity as retired sergeants. There should be no reason. And so that's why I'm raising these issues, and I'm also saying that I understand in connection with a member of parliament, a former member of parliament, there is one man who still has been unable to collect anything, I am advised, under the Parliamentary Pensions Act because he got caught up in the transition provisions between the abolition in 1989 and the present act. No, Galanis. Yes, right. I understand. And not only has he, what I'm advised is the egregious case is, well, that's why I'm raising it with you, because what I'm saying is, when you pass an act which appears to be specifically aimed at fixing up an individual, what you have then is many other people say, why aren't you doing it for me? Who are in lesser circumstances. Right. So I'm saying that you need to investigate these matters. And particularly since in the case of, and many people don't know this, the parliamentary pension is, you know, a contributory pension. And I'm advised he can't even get his contributions back. So that needs to be, that needs to be looked at and investigated. So, in principle, I see you've included the Commodore of the Defense Force, but clearly this was meant to be for the Commissioner of Police. I'm happy. I'm glad. I think the Commodore is probably happy that you thought of him also. But the Commissioner of Police unlike the Commodore of the Defense Force, is a constitutional job. It's not a statutory position. And if the Royal Bahamas Police Force is as close as we can get to an army. And we see that armies can act in very strange ways. You know, one day I was traveling home with the former Prime Minister Hubert Ingraham on an aircraft, and we landed at the then Paradise Island Airport. And so, as we looked out the window, he and I are sitting in the back seats together, and we're looking out the window. So there comes the Commissioner of Police and his men in khaki, you know, right behind him. So I leaned over to him and I said, Prime Minister, looks like you got the whole crowd out here to meet you. He said, yes, they are. He says, but let me tell you something. If you don't see them when you land, put your hands together and pray. Now, that's a bit of humor, but what it tells you, because you've seen in other countries, there's one country in this region, Grenada, that actually had a complete meltdown. Right? So you can't say, because we have these British traditions in Westminster and all the rest of it, that it can't happen here. So we want to be sure that we act to make sure that our institutions are in fact run in a transparent manner, and that these kinds of inducements as they appear are not necessary. And maybe you have to look at all the pension laws. For example, the question that's constantly asked is, one of the greatest liabilities, Madam President, that this administration has, whether they know it or not. And I see where they say they're going to accrual accounting. So I hope they accrue this, which is that there are unfunded pension mandates which are piling high every year. That means that everybody who is hired by the public service makes no contribution to the pension, and the government has to pay. So at some point, you know, what the Social Services Commission, which was headed by, I think, Mr. Reverend Alfred Stewart, recommended to the government, and this is not rocket science, I think these recommendations are in the public domain a long time, is that at some point the government has to move to a contributory pension. And given the way our contractual laws are, it probably means that you have to make that a requirement of new employees of the public service, and ultimately the pension mandate will run down to zero over the years. For example, I think the recommendations were made in the early 2000s. If we had done it, you would have had 10 to 15 years, 16 years behind you of this, and you would really see the mandate running down, moving toward a contributory pension.
Yes.
And so all of that is part of the reform that has to take place. I am therefore saying on both these bills that first, with regard to the pension, be careful that this does not appear to be an inducement. With regard to the bill on the DPP, that you are not creating problems for yourself by making something which is reviewable. And you know, with discretion, I'm watching what the government is doing on things like immigration very carefully. Very carefully. Very carefully. Yes. Yes. And I heard you loud and clear. I heard you loud and clear. Yes, I heard you loud and clear. You see, because that's again another issue where discretion is. You know, I was the minister. One man has a discretion as a minister, another man has a discretion. And I'm particularly concerned, Senator, about the fact that I've heard that a particular individual was taken off the restricted list and allowed back into this country in Grand Bahama. Particularly concerned about it, because there are compelling reasons why not.
I don't wish to don't wish to
The chair now recognizes Senator the Honorable Carl Bethel.
Thank you very much. I do not wish, please spell Rufa. I do not wish to have a legal argument or even a political argument. What I understand in regard to that is that there are instant legal proceedings that are being ventilated before a court of competent jurisdiction, I believe the Court of Appeal, that involve the persons, and they have a right to be present for the purposes of the presentation of their case. So I don't want to go any further than that. I don't want to have an argument. There was whatever the transactions were that brought things to the pass they reached, in my view, the matter being before a court of competent jurisdiction, they have the right to be present for that purpose. Thank you.
Right. I understood that that would be the government's position. I respectfully disagree. It's civil litigation. The person does not need to be in the Bahamas for that. Does not. And that's my view. We have to take our security very seriously, very seriously. And I just raised that as an issue. And so, Madam President, I thank you for this intervention. I think it's clear what our position is with regard to this. As I said, you can't reprobate and approbate at the same time, and be careful how you appear to create inducements when we are arguing in favor of transparency. So I thank you.